Yes.
Your Lordship, I beg to mention item number 8 on behalf of Mr. Opada, SIC. Lordship, I have taken consent from other side also. So matter may be adjourned for today.
Today means we'll take it on Monday.
Some week may be given.
Tell us exactly
2 weeks.
after a week on the petition.
Lordship, item number 26, supplementary hearing, Lordship. That I would like to mention for 3 weeks, Lordship, after 3 weeks.
Petitioner,
Yes.
appellant. You are for appellant?
Yes,
Respond.
yes, Lordship.
My Lordship, I'd like to mention item number 3 on behalf of M. Kato. Due to some personal difficulties, I unable to appear here. I'm for a respondent here. For a private case,
Adjournment is sought on behalf of whom?
Three.
Huh?
item number 3,
On behalf of
M. Kato, Mato Kato.
respondent.
Yes, ma'am. I've taken consent from the.
May I, Lordship, interim order is there. I am for the petitioner.
Interim order pass shall continue till next date of listing. So
Three.
what is this matter? This is an already order 39 rule 1 and 4 is pending, isn't it? That is to be decided anyway. Yes. Next case.
Much obliged.
May I plead your Lordship, my lord, I beg to mention item number 23, my lord, on behalf of,
23.
yes, ma'am, on behalf of D. Soki, my lord. He's out of his station, my lord. So this matter will be taken up after 2 weeks, my lord. And there's interim also, my lord. We will continue.
Office note reflects that this matter is ready as regards service. Accordingly, list this matter when?
After 2 weeks, my lord.
After 2 weeks. In the meantime, parties may exchange their pleading.
And there's interim also, my lord.
Interim order pass shall continue till the next date of listing.
May it please, Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship.
20.
20, Your Lordship, on behalf of the petitioner.
Same order. Service is completed.
Your Lordship, there is a interim, so it may be continued. Deeply obliged. 20.
20.
Deeply obliged.
Yeah, please, Your Honor. I beg to mention item number 5.
Item number
5. I'm appearing
5.
on behalf of the appellant, Your Honor, in this case. And Senior Counsel, Mr. Mukherjee is currently out
will
of
admit this
station.
appeal.
Pardon, Your Honor?
Will admit this appeal.
Okay, Your Honor.
Why should we take an adjournment? We'll admit this appeal. Huh? Heard your
T.Y. Bhutia.
T. Bhutia, learned counsel for the appellant. This is an appeal under Swenso. Peruse the ground of appeal. Also heard Swenso. You are for?
I am for victim.
This matter is ready as regards service. LCR is received.
Else.
LCR is received. Item number 5. Record has also been received. Full stop. Admit this appeal for hearing. As parties are duly represented, no formal notice need be issued. Registry to prepare the paper book and list.
Paper book is already
Paper
prepared.
book is also ready.
We have already received.
Already received. List this matter for hearing. When?
After 3 weeks.
After 3 weeks.
Deeply obliged.
G. Taro for additional purpose. Normal admission order. Appeal against Swenso. Parties are duly. Yes. Your name, please. Yes, next.
May I, Lordship, Lordship, I beg to mention item number 15.
1-5.
Yes, Your Lordship. Lordship, I'm appearing on behalf of T. Taba. Due to personal difficulties, he is absent today. So matter may be.
Matter is ready. Will fix for hearing.
Matter may be released after.
It's seen that the appeal has already been admitted. Service is complete. Paper book is also ready. And therefore, list this matter for hearing after 3 weeks.
After a week, Your Lordship.
After a week.
May I please, Your Lordship? Your Lordship, I would to mention item number 28, Your Lordship.
Item number
28,
28.
Your Lordship. Your Lordship, matter may be fixed after 2
Huh?
weeks, Your Lordship.
2 weeks.
Yes, Your Lordship. Much obliged.
Yes. What is the sessions case number?
My lord,
What is the sessions case number?
session case number, my lord, is still not yet given.
Huh?
Session case number,
Huh.
not yet given, my lord.
GR case number?
GR case number, it is there, your honor. Zero three.
Where do we get
No,
it?
it is GD. It is GD number here.
See, we will have to call for the scan copies. Already
Yes.
search sheet is filed.
Yes, my lord.
What scan copy from which court? Until and unless you disclose that. This
Yes.
is the difficulty I am finding.
Yes, Your Lordship. Because basically the charge sheet is filed before the CGM initially, then commitment comes.
We do not know.
Whether it's
what is
committed
the-
or not.
Where it is pending, from where we will call the scan copies. To grant you bail and to
Yes.
consider your bail, we'll have to ask the registry to bring the scan
record.
copies of the record
Yes, sir.
as well as the scan copy of the bail, case diary,
Yes, my
so
lord.
that we can appreciate
From
from whom in reference to which case.
from session,
Huh?
from the session court, my lord.
Sessions court case
You-
number,
My lord.
police case will not do. This is the difficulty.
Sure.
Mr.
Let them get the.
Panging, this is the problem I am facing everywhere.
Yes, my case was the last occasion they did.
So it is very difficult. See, it will difficult for registry. Who will search which police case is pending, which court?
My lord, generally you need to file charge sheet before the.
No, see. It, with my limited understanding, an FIR is registered, a police station case is registered, investigation is done, search sheet is filed before the jurisdictional magistrate.
Yes, my lord.
Is that it?
Yes.
Now, if it is a triable by the magistrate, magistrate will try it. There will be a case registered, maybe in the name of GR case, PRC case, anything. And if you are in jail, if you want a bail, we'll have to call the material from the jurisdictional magistrate. So we must know it is pending before which jurisdictional magistrate. Number one. Suppose it's a case of sessions tribunal. We'll have to know whether that has been committed to the sessions court.
Yes.
If it is committed to the sessions court, there will be a number, sessions
Yes,
case
yes,
number.
my lord.
Then we'll have to call it, please bring the record from so and so, so and so, so and so. Nothing is there in your petition.
So, my lord, if you already committed to the session court, of course, I have not been mentioned there in my
That
petition, my
is
lord.
very vital. You mention it and we'll call it.
Yes.
So I have not mentioned it.
I took a decision while going through this file that no, on Mr. Panging's case, I was a little bit lenient, but that this is creating a havoc. Then only
The courts are also not mentioning the numbers in the getting certificate.
how the registry will call a record? We may say the so and so Itanagar police station case. That may be in different courts. Maybe subdivision magistrate, maybe CGM, maybe sessions, maybe additional.
Maybe your notice may lay down some because this is the.
No, this is not laying down. This is the procedure.
Yes, sir.
I'll have a talk with the registry.
Yes.
We are fixing this matter on Monday.
Yes,
Okay.
yes, my lord.
You try to collect it.
Yes, my lord.
Please this matter on Monday. I will have a talk with, we'll ask registry not to register cases without mentioning, and we'll ask the Registrar General to intimate all the courts.
Yes, sir.
On Monday,
Monday.
oblige,
On the
oblige,
prayer of the learned council for the list this matter on Monday. It
oblige.
is good for everybody.
Lordship, I'm extremely sorry. Earlier I have mentioned item number 3, which is actually in item 4. In my course list, there is wrongly printed here.
Huh?
So, yes, earlier I have mentioned item number 3 is actually item number 4.
You want to adjourn item number 4?
Yes, actually.
Who is for item number 3?
I'm sorry, I don't know. I'm sorry, in item number 4, it's
We are there, my lord. Even we are seeking an adjournment, my lord.
Okay, 3 is already adjourned. Now 4 also adjourned.
I'm extremely sorry.
Okay, item 2.
Deeply obliged.
Now call item 2.
May it please your lordship. My lord, This is a 482 application, my lord. FIR is at page 30.
We'll call for a case diary.
Uh,
No
my lord,
interim.
my lord, motion is actually over in this case because we had moved it before the vacation bench.
Where
on
is
8.
that motion order? Okay, case there is there.
Yes.
Case there is there. Okay. Yes, Argu.
Yes, my lord, FIR is at page 30, my lord. The allegation is that one Mr. Partha Bhardwaj, my lord, he impersonated himself as the director of Matak Autonomous Council and awarded a work to the informants firm, my lord.
This is not a single case. I have already rejected bail application in Guwahati. This Motok now I did not know that this Motok had come to Itanagar.
But I'm not that associates of Motak organization, my lord. I am the agent of the informants firm, my lord.
You
Because
are?
I'm Kuldeep Saxena, my lord. I'm a Delhi-based service provider firm, my lord, and I provide bid facilitation.
You are the middleman between the person who committed fraud and
No, my
the
No, my lord. I was engaged by because my lord, that is why, my lord, I have annexed certain documents, my lord. Because
yes.
this is not the first time, my lord. I have provided service to various other firms in Arunachal Pradesh earlier, my lord. My lord may currently come to page 37, my lord. This is message
What kind of service do you provide?
because earlier occasions there were no cases against me, and my lord may kindly come to page number 66, my lord. Page number 66. What the fees that I have taken from my client, my lord, that is the informant, we have paid GST, my lord, tax. It is a genuine firm, and whatever fees we take, we pay taxes and all, my lord.
Page 66.
Page 66, my lord. We take 2% of the supply work order amount, and that amounted to 1 crore 5 lakhs, 6 lakhs. That is only we have taken, and we have paid
No.
taxes.
Please tell us what kind of service do you provide?
My lord, this preparation of documents and those tenders involving huge documentations, these clients engages us for preparing those documents, my lord. Now, whether Partha Bhardwaj is a fraud or not,
Documents for what purpose?
my lord, to facilitate the bid, my lord.
Where
Because
is the bid? There was no advertisement. Here, your case is this, that somebody came and said that I can give you work order. This is the work order. I am the representative of Moto. Where is the question of giving tender and all?
no, my lord, after, because in the FIR itself, they admittedly, the informant has said, my lord.
Let us see the FIR.
FIR, my lord, is page 30, my lord. At second para, my lord, with utmost regards, it is to inform your good office that during the month of April 23, from some reliable sources, it came to know that the supply work of solar street light under the area of Matak Autonomous Council was about to be awarded, and accordingly, we met Sri Kuldeep Saxena. So after they came to know about the work, they contacted this petitioner, my lord, to facilitate this tender process. It is not this petitioner who informed them, my lord, because we have annexed various documents.
There is no tender. It is to be awarded.
Yes, my lord.
It is to be awarded. This what is the other person Partha said that
Yes.
I have a capacity to give you the work order of rupees so and so.
My lord.
And this Partha's intimation was given by Kuldeep Saxena to these parties.
No,
The
my lord,
CEO
that is not the allegation, my lord.
Yes,
Because
about to be awarded. Accordingly, it made Kuldeep Saxena
Yes,
alias Kuldeep, who
yes, after-
called us to meet him at Delhi. Thereby, I sent my two staffs to meet him, and he provided details of procedure to get supply of.
Yes, my lord.
Okay. And again, Kuldeep Saxena asked us to come down to Guwahati to meet Managing Director of Matak Autonomous Council, Partha Bharadwaj. Partha Bharadwaj is not the Managing Director of the Matak Autonomous Council.
Yes, my lord, but that
Then-
petitioner doesn't know, my lord, because it is the informants firm who engaged us. My lord, may see the engagement order, my lord.
This is not a case for anticipatory bail.
My lord, earlier, my lord, we have placed all these records before the session judge. We are granted interim bail, my lord, and we came from Delhi and we appeared also, my lord. But
it
that
was
was and
but that was cancelled.
yes, my lord, and the ground for cancellation is, my lord, something because
No,
when this petitioner came down
because
to
he was not cooperating, it was
no,
cancelled.
my lord, he came down
Twice
from
it was
Delhi to
cancelled,
Itanagar,
interim bail.
and certain things developed, my lord. When he came down to Itanagar, these informants, they on gunpoint they took 6 checks from this petitioner, my lord. 6 checks they took on gunpoint. We informed the police also, but they did not register any case. Then we filed an FIR at Delhi, my lord. And this bail was cancelled on the ground that these 6 checks were dishonored, my lord. But we have also annexed our bank statement on the date of filing, my lord. On the date of this,
Don't, these are not subject matter. Rose, sake, and these are business transactions. Will come later.
my lord, this FIR is
Earlier it was somebody, some Vastu experts. Isn't it? Earlier it was some Vastu experts who called somebody and hundreds of crores of rupees of work order was issued, impersonating them as a CS officer, then
Managing
the
director.
chairman of the managing director of the Motok Autonomous Council, and issued fake orders.
With
Yes, my
tax
lord. Against Partha Bhardwaj, there are numerous cases, my lord. These are pending, my lord. But this petitioner, my lord, he is a genuine service provider, my lord. He has done several other cases, my lord, but there is not a single case against him. And he has also returned 30 lakhs, 40 lakhs till date, my lord.
And there are more member of these syndicates which are yet to be revealed by the other co-accused. And one is already arrested.
Yes, Partha Bhardwaj was
On-
arrested, my lord. He is the main culprit, my lord.
Both the joint interrogation of both of you are required. We'll observe that.
Exactly yours. Jointly, they have committed this offense.
Will be required.
My lord, he will cooperate, my lord. His wife is pregnant and developed certain complications. His mother has also suffered cardiac arrest. We have annexed medical documents, my lord.
Mothers will
He
suffer.
will cooperate, my lord.
When this kind of son is there, mother will definitely have a cardiac arrest.
My lord, he will cooperate, my lord. Indeed.
That's all?
Yes, my lord. And we have
Hard.
returned 40 lakhs till date, my lord.
Hard. Why have you returned it if it is a genuine fee?
Because, my lord, there is a goodwill in Arunachal Pradesh of this petitioner,
What?
my lord.
Hard. You are Mr. B.D. Deka.
DK Medhi, my lord.
D. Deka.
DK Medhi, my lord.
DK Medhi.
Yes.
And you are for whom? Okay. Medhi, learned counsel for the petitioner. Also heard Mr. Swenso, learned additional public prosecutor. The present application is filed under Swenso, King Swenso. In the affair, it is alleged that the present petitioner tried to facilitate work order for solar street light under the why this is in Arunachal? This is registered.
Register, yes, in Chimpu PS police station.
Why? Who is information from Arunachal?
Yes, one is from Arunachal.
But the entire incident happened at Guwahati, my lord.
That you can seek something transparent. All we are not.
My lord.
What do you say?
Two are from Arunachal.
That informant is also for a shortcut money. Without tender, he will supply hundreds of crores and so spend money. Now he has become wise. He, in fact, is a criminal, isn't it?
Yes.
Can
Invested,
anything be awarded without a tender this this magnitude?
invested 6 crore at the 7 lakhs.
How much?
6 crore at the 7 lakhs.
Here it's a lesser. Earlier, Motok Autonomous Council was about 120 crores. Supply of some, what was that supply? I forgot it. And in that case, it was facilitated by one Vastu expert.
Okay.
Where is it? Solar street light under the area of Motok Autonomous Council. And in the process, the present accused introduced the informant with one Partha Bharasdas, claiming to be managing director of Motong Autonomous Council. Full stop. As per the FIR, said Partha Bharasdas asked the informant to deal with the present accused and the PA of Partha Bharasdas, namely Minal Kumar Sarkia, and in the process, said Mrinal Sarkia issued a letter of award for supply of solar street light on 27/6/2023, bearing the seal of Motok Autonomous Council. Thereafter, both the it is also alleged that thereafter, both the present petitioner as well as the aforesaid Minal Kumar Saikia asked the informant to wait for signing of an MOU. However, according to the informant, the aforesaid came to be a fake document, and they could also learn that the aforesaid Partha Bharadwaj is not the managing director of the of Motok Autonomous Council, and that Motok Autonomous Council did not issue such supply order. In the aforesaid backdrop, FIR is filed. Full stop. It is contended by the learned counsel for the petitioner that the petitioner is a service provider to assist business houses to prepare for tender documents and for supply of works which requires several documentation. And on the request of the informant, they have prepared such documents and also legitimately charge them bills, their remuneration by paying GST. Therefore, the petitioner cannot be said to be involved in the commission of offense, and there is also no truth in the allegation that the petitioner is having any nexus with either Partha Bharadwaj or with the other accused Mrinal Kumar Saikia. Therefore, petitioner be granted anticipatory bail. It is further contended that the petitioner was initially granted interim protection by the learned session judge. Which session judge?
UPA.
Learned session judge UPA, and they had duly cooperated. The petitioner had duly cooperated with the investigation. However, alleging non-cooperation of the petitioner, subsequently bail was rejected. Therefore, this is a fit case. The petitioner should be allowed to go on anticipatory bail, in as much as there is no flight risk of the petitioner, Per contra, the learned additional public prosecutor, referring to the different materials collected by the investigating authority, submits that the present petitioner is the kingpin and co-conspirator with Kuldeep Partha Bharadwaj and Kuldeep Saikia, and it is the petitioner who has introduced the informant with with Partha Bharaddas and Kuldeep Sakya. Therefore, therefore, joint interrogation of the petitioner may be necessary along with already arrested accused Partha Sakya, and accordingly, he submits that the petitioner shall not be shall not be granted privilege of pre-arrest bail, inasmuch as in the investigation will require his interrogation.
Interrogations.
I've heard the learned counsel for the parties peruse the case diary. The material so far collected by the investigating authority suggests that the present petitioner and his associates are has created fraudulent memorandum of understanding, issuing forced work order and counterfeit government stamp involving a total amount of 6.87 crores. It is also suggested by the IO in his case diary that the present petitioner had played an instrumental role in the fraudulent scheme, misrepresenting himself as an authorized representative with influence over the Motok Autonomous Council for awarding the scheme, and that the present petitioner has portrayed itself as authorized council officials by using authorized representative by using fabricated government seals and letterheads. Full stop. It is also suggested by the IO that over 1.87 crore was accumulated by the present petitioner in his personal and his wife's bank account under the guise of process fee and cut money for link official. Full stop. This court has also considered the stage of investigation. It is in the opinion of this court, the investigation is at an early stage.
Yes, natural stage.
Early stage, and therefore, considering the material so far collected as recorded herein above, this court is of the opinion that this is not a fit case where the privilege of pre-arrest bail should be granted. Accordingly, the present anticipatory bail application stands dismissed. Case diary is returned back.
Obliged.
Obliged.
Whole matter during the pendency of a suit before the senior division.
Who is for the other side?
They are just not appearing anymore, madam.
Where is that suit?
41, madam.
Page 41.
Yes.
Heard Mr. D. Pangi, learned counsel for the petitioner. Where is the impugn order?
They have a 5 copy, my lord. Page 54.
Page 54.
Starts from 51.
An order dated 12/4/2023. Passed by the Gaobura, is that it?
Yes.
Gaobura of
It is Seram village, madam.
Gaobura of Seram village. Whereby whereby it was held that Bangkok village existed on being permitted to be settled by forefathers of Siluk village and the landowners of Bangkok land were directed to construct a traditional community hall and also to perform traditional rituals for the land. The petitioner, namely, who has imposed this? Who is Olom Doso?
That is the person who sold to us.
Huh?
That is the person who sold the land to the petitioner.
Okay.
Olom Doso is the person.
Okay. The vendor of the present petitioner, namely Olom Doso, was imposed with a fine of rupees 2,500 for not attending the kebang. From the aforesaid, it is the case of the petitioner that the aforesaid Olom Doso, is not it?
Yeah.
Sold his plot, his land to the present petitioner. To the present petitioner. And the same land is directed by the Keba for to facilitate construction of traditional community hall. Is not it?
Yes.
This is your case, community hall. Full stop. In the aforesaid backdrop, it is contended by Mr. Panging that the dispute and subject matter it was already pending before the trial court, before a competent civil court in civil suit number,
Title suit number 8 of 2023.
in title suit number
8 of 2023.
8 of 2023,
Page 41.
page 41.
No,
8 of 2023, between the present petitioner and
the response.
the
Respondent.
respondent. The record reveals that the title suit 8 of 2023 was filed by the present petitioner against defendants, against the respondents, including the said Olom Doso,
Yes.
that is the vendor of the petitioner, who was imposed with cost by the Kebang. And the aforesaid suit was declaration of right, title, and interest with consequential relief of permanent injunction over the suit land, which was also the subject matter of the Keba decision. In the aforesaid backdrop, on 6/4/2023, and the Keba decision was passed on 12/4/2023, and therefore such Keba decision cannot be implemented, nor the Kebang was within its jurisdiction to entertain such a claim when a civil suit was pending. Full stop. None appears for the respondents to contest the matter, though their names are shown in the cause list. Full stop. It is seen from the record that the subject matter of the title suit number 8 of 2023 is a suit for declaration of right, title, and interest over a plot of land measuring approximately 1248 acres located in Bangkok area under Mebo. It is also seen that the lands are similar, and the Keba decided that said land is a community land, and therefore they has declared that a traditional community hall be constructed over this land. However, at the same time, the right, title, interest is the subject matter of a competent civil court. In the aforesaid backdrop, In the aforesaid backdrop, in the considered opinion of this court, the civil suit is to be allowed to be proceeded, and the decision of the KEBA dated 12/4/2023, which is subsequent to filing of the title suit, shall always be subject to the final determination made in the civil suit. In view of the aforesaid, it is provided that if you have said, the impugn order dated 12/4/2023 passed by the KEBA, is that it? KEBA of GB Seram is interfered with by setting aside and passing the same. Full stop. The parties the same. However, while parting with the record, it is made clear that this court has not commented on the merit of the claim of the petitioner, the defendants in the title suit number 8/2023 or the decision of the KEBA dated 12/4/2023. It is also made clear that the KEBA may get themselves implicated in the title suit, and the petitioner plaintiff may also implicate them in the title suit because they are.
KEBA is now being conferred with the status of customary court.
Then okay.
The parties are already there.
Oh, parties are already there. Thomas, since the parties are already there, full stop. Accordingly, in the aforesaid, the present civil revision petition stands allowed. Now the trial court shall proceed with the title suit. Disposal. Yes, what is your case?
My lord, this is a case of putting the cart before the horse. There was the petitioner issued two check in terms with the agreement dated 6/9/2022.
Agreement is
6/9/2022.
6/9/2022 agreement.
In terms with the clause 5 of the agreement dated 6/9/2022, the petitioner issued two check.
What is that clause says?
And this agreement, deed of understanding dated 6/9/2022, clause 2 says if 2% of GST is reflected in the Department of Municipal Corporation Itanagar, then this check, this impugn check has to be deposited. But without there being any reflection of 2% of GST amount in the Department of Municipal Corporation, they have deposited the check, thereby giving rise to illegal cause of action for filing the complaint petition. Thereafter, again, and my lord, clause 4 of the deed of understanding dated 6/9/2022 says that amount will be given to the first party by the second party, by the petitioner to the respondent, as and when the pending bill is clear from the competent authority, that is Itanagar Municipal Corporation. But we have annexed the certificate issued by the municipal corporation prior to filing of this complaint petition, being complaint petition case number 100/2022 before the learned JMFC court at UPA, prior to release of the fund.
Check was deposited.
Check was deposited. Obviously, it will be check will get bounced because the amount was not released by the department.
Sum and substance of your argument is that the amount did not become due on the date of submission of the check, And therefore, this is not an enforceable debt.
Yes.
Can that be decided in a 482 petition?
My,
This needs factual assertion.
my
You'll
lord,
have to exhibit, this is my certificate. Okay, this is my agreement. Clause 5 is such and such, exhibit 1. Clause 6 is exhibit 1, 2. So therefore, in view of this, on that day, then you will have to exhibit a certificate of the municipal corporation that this has not been paid. Can that be done in a high court?
my lord,
Tell me, how can you decide that this is the agreement? How can we decide that this is, that needs an evidence?
my
That is
lord,
what-
this agreement, it is filed by them in their complaint petition.
You understand, this is the agreement filed by them in their complaint petition. Now we'll have to determine that on that day it was not paid. This condition was not fulfilled. Can that be done in a 482 application?
My lord, when the terms and conditions was violated,
You are not getting my point. It is your allegation that terms and conditions are violated. Therefore, it was not due. What is 138? There is a presumption that when check is issued, deposited, dishonored, there is a presumption that it is an enforceable due. If you discharge your burden saying, primary burden, saying that this is not due, because this is the agreement, this is the clause, or on that day there is no release. Now the burden will shift to him to prove that yes, it was paid, this has become enforceable due. Then court will take a call. Now you are asking us to do all these exercise in a power under section 482. Is it permissible? If you can show this is permissible, we will proceed.
my lord, there is other ground also, that the mandatory legal notice was also not served.
But that can be a ground.
Yes, that is there. I'll show.
So your first ground is gone.
Second ground is also there, my lord.
But
Or this a dispute of fact, which has to
My-
be
my
put in
lord,
a trial
That
court.
is
Lord.
what I- See, you say that notice was not served,
Yes,
notice was
mandatory-
not issued.
Page number page number 39 of my petition,
PS number.
39.
Hmm.
This legal notice was issued.
This
To
is
the
examined,
petitioner.
What? What is the stage of this?
Lordship, the Honorable High Court has stated the matter since as of now the it's pending before us in cabinet events.
So why this exhibit is marked? Trial started.
Trial is started, the Honorable High Court, but this by order, they have stayed the proceeding, Lordship.
No, tell me, what is this 839?
This is the legal notice issued by the
What you want to
complainant.
argue from this?
That
Yes,
My
please.
lord, kindly see the address. That this legal notice, this legal notice was issued by one advocate, Vijay Jamo, if we see, and the address of is of the Itanagar and pin code is of the Narlagan, 79110.
Oh, we understand. Now they will have to establish by evidence that this notice was issued, this is the postal receipt. If
My-
necessary, they will have to bring the postman to the witness box saying that yes, I have delivered or not.
My lord, but the postal slip which they have enclosed in their annexer, it was one which is sent by the S string and not by Vijay Jamo.
Maybe, whether you have received it or not. Did you
We
receive?
we
it?
have not received it because
So you have not received. This will be your defense. Now he'll have to prove. See, forget about other things. Though there is a presumption, he will have to lay the foundational fact. First, he'll have to say that this is the check. He'll have to prove the check. This is the check issued by so and so, so and so. He'll have to bring bank official, seeing that this is my return memo. Now I have become a teacher.
Yes, Lord.
then my lord in that
Lordship,
case,
basically what my for interpreting Lordship.
He's a young counsel, that's why I'm deliberating with him.
Now, with regard to the clause agreement, that check was presented prematurely, thereby violating the terms and conditions.
Understand?
On that regard, I'll do some research, so some time may be given.
We'll give you some time. We are not dismissing your petition.
Yes, it may be fixed after 1 week.
After 1 week.
Yes.
After I leave, I will give you a method case.
Lordship, this matter may be taken up before this bench. Lordship, I'll just format.
No, no, just-
I need
just,
some
yes, silent,
sufficient
just
time to
yes,
research
silent.
on this.
You have filed an 482 petition. First, you get yourself understand what is the parameter and to what extent a 482 power can be exercised. You read Bhajan Lal fast, and there are many other judgments.
Yes,
Next.
my lord.
Next thing is that we cannot endeavor into factual determination. What is factual determination? You say that these conditions are not fulfilled. He is saying conditions are fulfilled, therefore this is a legally enforceable due. You are saying this is not legally enforceable due. That cannot be decided under 482. You are saying notice was not served. He is saying notice was served. This is his case. That cannot be determined without taking evidence in this court.
My lord, in that case, I may be given sufficient time to research on this. At least 2 week times may be given.
There is no research I can dictate the judgment right now.
Since Lordship, there is an stay by this honorable court. Lordship, I'll just coming to page 59.
Don't come to the
Okay.
place. We are giving him time. A breathing space.
2 weeks time.
Weeks. But this is the issue. You cannot change your case. Maybe there is a stay. On the prayer of the learned counsel for the petitioner, matter stands and be adjourned for 2 weeks. Interim order pass. I just give a date.
Any date, my friend.
Give a date. You cannot come to the court
November
on
13th.
482 as and when you wish. No. Yes, November
14th.
14th. Okay, fine.
Fine.
Yes,
Leave
next
over.
case. This court in Guwahati, it would have been declaration would have been completed by now. Item? Who is for a petitioner? This is also case for dismissal. A father cannot,
Yes,
parents cannot compromise on behalf of the
Yes.
minor. And specific allegations are there.
yes.
It cannot be. None appears for the petitioner on call. However, in the interest of justice, matter stands adjourned and will be stayed after 4 weeks. It cannot be. His daughter's friend, isn't it? The victim was daughter's friend of this accused, isn't it? Something like that.
No, informant is father and this accused is a teacher, tuition teacher.
Tuition. Okay, this is tuition.
Mm.
This is also difficult. Cannot be. You are a minor at that point.
Yes, Lordship. I am represented by Madam.
On the prayer of the learned counsel. Today is a Friday, that's why you are saved. Otherwise, it is a case for dismissal. On the prayer of the learned counsel for the petitioner, matter stands adjourned and will be stayed after 4 weeks. Cannot be a lady, senior lady, you will molest and it will give a license to you. That yes, we can do it and compromise it.
Well, this is application under section 528 of BNS. Praying for quashing of the GR case number 9 before the JMFC Colorian. in connection with the PS case number 4 of the Coloria, wherein the allegation, the case has been registered under section, my lord, 166
This is
A-
item number
11.
11, item 11.
11.
166A of the IPC and 134 of the People Representative.
What is this? His name was also not there. Is that it? Election duty?
Of course, my lord, my name was there.
Hmm.
What is the, my lord, what is the case is that while I am, my lord, one of the advocates. And while, my lord, I was there, I was appointed as a legal counsel in the one-stop point scheme, my lord,
Hmm.
in the Department of the Development of the Child and the Women.
Where is the affair?
My lord, may I kindly come to the page number 21, the FIR. This
Page,
FIR
page?
21. This is about copy and the original.
Is it election? Election,
Yes,
isn't it?
matter pertaining to the election.
Who are you?
I, my lord.
You are
I-
a government official.
No, my lord. I am advocate and I was the counselor for the, my lord, one stop point scheme. Man.
Councillor?
Council in that particular scheme, one stop point. My lord, attached with the Department of the Women and the Child Development. Wherein, my lord, I used to advise in the petty cases where, my lord, certain problems.
Now, what is the allegation against you? I'm not
Allegation, my lord, allegation against is there, my lord. I was entrusted to attain the election duty, and accordingly, I have
Election
accepted.
duty attend as a governmental, as a law, how a lawyer can be asked to attend election duty? Are
Despite
you a government on a payroll or what?
no. So, despite of that, what happened, my lord? Due to sudden illness.
No, no, forget
I
about
could-
the sudden illness. How can you be forced to participate in an election duty?
My lord,
Yes.
that
yes,
is the
exactly.
mere.
Huh?
Exactly. Advocate, he's also he's engaged.
Suppose suppose some government advocate is a government advocate here, representing election commission, say for a moment, state election commission. Can election commission say that you do your duty in the election duty?
No,
Huh?
no.
Forget about other things, whether he filed application or not.
This is a pit case.
Huh?
Pit case to be allowed.
Fit means it's absolute fit case. Hard. Swensu, learned counsel for the petitioner. That is why I got confused in this case.
Yes.
Who are you? And you have given explanation that you ought to have refused it. Why should we go? Then tomorrow he will also be asked to do election duty. Isn't it?
Yes, ma'am.
Who is this officer?
Well,
District election officer. He should know his business. Hard. The petitioner herein where is your introduction? That you are lawyer and all. Which paragraph?
Malan in paragraph number 5.
Paragraph number?
5, page 9.
You are a law graduate or what?
Matter.
Huh?
Low grade.
The petitioner who is a law graduate was engaged as legal counsel of one-stop center within inverted comma. One-stop center at Colorium under Women and Child Development WCD. Colorium as a contractual staff in a centrally sponsored scheme by the central government Be that as it may, he was asked to perform election duty in connection with election of
2024, last election.
election duty in which constituency?
At Coloriam.
In what is the number of the Coleraine constituency?
One of I'm sorry, constituency, not here, but I was at 21 constituency.
21 Colorium constituency in the last assembly election of the Legislative Assembly of Arunachal Pradesh. Stop. Arunachal Pradesh. It is the case of the petitioner that though he was not under bounden duty to participate, to serve the election procedure in view of his status and nature of work being a legal counsel. However, he was willing to serve the election, process, but due to his sudden illness, he could not attend the election process. It is his specific stand that he had serious health problem, and accordingly he had to undergo treatment at Niba Hospital, Papunala, Naharlagun, and the same was duly informed to the authority, that is DEO Kurung Kame, by filing leave application on 9/4/2024 on medical ground. He was taking regular antibiotic injection at the aforesaid hospital due to his serious health problem. Full stop. Such stand of the petitioner gets support in the materials collected by the investigating officer. Full stop. In the aforesaid backdrop, the election officer, where is the affair?
Page 21.
Huh?
Page 21. Huh?
Page 21. The election officer lodged an FIR. No, not in that background, it's just deleted. It is also on record that the election officer, where is the page 21? It is also on record that the district election officer, Kurungkame district, Colorium, filed an FIR on 17th of April 2024 alleging that the 12 persons named in the affair,
23%.
23 persons named in the affair has willfully neglected and refused to discharge the election duties and responsibilities assigned to them. And accordingly, a regular case under section 134 of RPA Act, Representation of People's Act, 1951, and under section 166 within bracket small a IPC was requested to be registered. Accordingly, Colorium PS case number 04/2024 under section 166A IPC read with Section 134 RP Act 1951 was registered. It is interesting to note that the name of the petitioner did not find a place in the affair. Is that it?
No, my lord.
Huh?
Name of the petitioner is in serial number 17.
Serial number 17. Okay.
Ma'am.
Okay. Oh, no, not necessary. Full stop. Full stop. Full stop. Now the petitioner has assailed the aforesaid proceeding by way of the present petition. Full stop. Perusal of the material shows that the perusal of the material, your record is there.
Yes.
You recorded your statement before the IO.
Yes, that already taken and charge sheet also already filed.
Come on. The petitioner's statement was recorded by the IO, and after completion of the investigation, charge sheet was also filed. Being charge sheet number page
Page, my lord, start from 46.
46, charge sheet.
My lord.
Being charge sheet number. Being charge sheet number 04/24 under section 166A IPC, read with section 134 RP Act 1951. Full stop. This court has perused the material available on record, including the statement of the witnesses, the statement of the petitioner, and the documents. The documents available on record. Full stop. From the aforesaid, it is seen that if the material so far collected by the IO is taken, which is for face value, and is taken to be correct, it is seen that the petitioner has explained his inability to attend the election duty on the basis of, for the reason of his serious health condition. Full stop. In view of the aforesaid, in the considered opinion of this court, the charge would not have filed against the petitioner. Accordingly, the present application stands allowed by setting aside the by directing the petitioner, directing that the petitioner's name should be deleted. As the accused in the charge sheet, and he shall not be tried for the offense as alleged. None appears for a petitioner on call. Office note reflects that service is complete. Accordingly, list this matter in the admission column after 3 weeks.
Obliged.
My lordship, respondent number were supposed to file an affidavit.
This matter is ready as regards service. Full stop. Though time was taken by the respondent to file counter affidavit, no such affidavit has been filed. Full stop. List this matter after 2 weeks in the admission column. In the meantime, the respondent may file their reply affidavit if so advised. Okay. None appears for the petitioner on call. Office note reflects that service is complete. Accordingly, list this matter in the admission column after 3 weeks.
Right.
Hmm. 15. Isn't it?
No.
15 to 16. 16. Yes.
Oh. So, my
Yes,
lord,
no wakalatnama file.
Lordship, the respondent is not in station as well.
Huh?
The lordship is not, the respondent is not in station, lordship. That's why we could not file.
Respondent.
It's not in station, out of station, lordship. So that's why we could not file the wakalata.
Though Mr. You are Mr.
Jita, lordship.
G. Taro, Learned Counsel, submits that he has instruction to appear on behalf of the private respondent. However, due to absence of the respondent, the wakalatnama could not be executed and therefore he has not been able to file the wakalatnama. Accordingly, he pressed for an adjournment.
One thing, my lord, the respondent number 2 started his appearance since 30/7/2024. And thereafter, my lord, so far the last order is concerned. The interim order is supposed to be considered, my lord. Because, my lord, what is uniqueness?
Okay,
in
what
this-
is the case here?
My lord, uniqueness in this present case is the informant is the resident of the Kanpur, Uttar Pradesh. And at the same time, the accused, no, all the accused are from the Gwalior at the Madhya Pradesh. An incident took place in the years 2018 at the Madhya Pradesh. And now the FIR has been lodged before the Itanagar police station on the ground that the fathers of the informant is serving as a police officer in the Itanagar Capital Complex. So, my lord, these respondent.
Where is the affair?
Yeah. Therefore, my lord, I am seeking for, my lord, interim, FIR in my lord page 17 to 21. The main portion is page 17, ma'am.
Now, what about page 78?
To the jurisdiction issue, Lordship, yeah, I believe, Lordship, there is a judgment by apex court that the complainant, the wife, can file a complaint.
This
where to be taken.
498A
498.
by my lord Justice Gogoi.
Yes, yes. Rupali Devi.
That cannot be a ground. I have passed judgment. That is well settled.
Any place.
When it is 498A, the FIR can be filed any place where the lady takes shelter. That's all.
Yes, sir.
This is the ground.
My lord,
Then we'll dismiss this.
no, my lord, the ground, my lord, at the relevant point of the time, the sheltering place of the ladies was, my lord, at Kanpur.
Whatsoever, if she is
Escape one.
here, settled here and file the FIR, that's all. I have a judgment,
And
detailed
at,
judgment.
and at the same time, so far, my lord, trial is concerned.
Better get it adjourned by my lord Justice Gogoi.
Yes, sir. Is there.
That law is well settled. So far relating to 498A, whenever she takes a settle and if she is the victim, she can file FIR and at any place.
Yes, Your Lordship. And so far as Your Lordship, investigation is concerned, the investigation can be done by the
Yes.
police station without having jurisdiction, Your Lordship.
Yes. In case of 498, there is no question at all. When it is an atrocity against a woman, now this is now being slowly expanded, not
Yes.
only 498.
Yes, other cases also, Your Lordship.
So dismiss it or give an adjournment to him.
My lord, give him chance.
Give him an adjournment. Because he is not having the wakalatnama. Accordingly, matter stands adjourned and be listed
Obliged, Your Lordship.
after 3 weeks.
Please, Your Lordship.
Yes, what about the OC? Just have a talk to him. No service is received from the officer in charge. Office note dated 24th and 2024 reflects that service report, service of notice and its report, service of notice upon the victim and the report is not yet received from the officer in charge of Pasighat Police Station, East Siang District. Full stop. Will you take a fresh step so that we can direct her in terms of the
Yes,
notification?
yes.
In the meantime, the learned additional public prosecutor shall obtain instruction from the concerned officer in charge as regards status of service. What is the offense here?
Section 8 of POCSO.
Okay. From the officer in charge, Pasighat Police Station. In the meantime, the learned counsel for the petitioner may take fresh steps in terms of notification number 17, isn't it?
Lordship, last time the registry was directed. Since I'm a legal aid counsel here.
So therefore,
Yes.
in the meantime, the registry is to issue notice for issue notice to the victim in terms of the notification number so and so, dated so and so. This notification gives, then registry will give the details to the office of the PP. PP will give it to OC and OC will have to give the report. On the next date fix, the officer in charge, Pasighat Police Station, shall invariably submit a status of service upon the respondent number.
Lordship, may I also pray, since the records have come, the LCR, the paper book may be direct to be
Okay.
prepared.
As the LCR has already been received, registry may prepare the paper book, furnish the same to the learned councils, including the legal aid council, and list this matter after 4 weeks on or 3 weeks. It may require paper book.
Lordship, as this is a POCSO matter, Lordship, then victim said if nobody appeared, then LSC may be
But
appointed.
first we'll have to know that
Lordship.
service is complete.
Lordship, that's
Then
what-
we'll
Then after that, we'll fix the date. Lordship.
Okay, list this matter on for the service report. Then IO officer in charge will know that I will have to submit this
Lordship.
report on such and such date.
Then after 3 weeks, Lordship.
Give a date. This is
20th November.
Huh?
20th November.
28th of November.
Oblige.
Await service report in respect of the sole respondent. List this matter after 3 weeks with an updated, after 4 weeks with an updated service report. Heard Mr. Sesadri, learned counsel for the petitioner.
May I please your lordships?
This is an application under, this is an application seeking review of order dated, order dated,
16th August 24, my lord.
Order dated 16th of August 2024, passed in arbitration petition /2/2024. So and so accept notice on behalf of all the respondents. Full stop. Let this matter be listed in the order column on, give a date.
Anytime after Diwali, subject to your lordship's convenience, my lord.
Give a date. I have convenience every day. Yes, give a date. On 10th of November.
Grateful, my lord.
10th of November.
Grateful.
11th of November.
Grateful, man.
11th. We'll see.
Grateful, man.
In term, office note dated 23/10. Yes, are you appearing?
I'm for the respondent, Lordship.
Respondent who? Which respondent? Sole respondent.
Yes.
Full stop.
Uh,
Though office note dated 23/10/2024 reflects that service report in respect of the sole respondent is not yet received. However, Mr.
A. Gamre.
Submits that he has entered appearance on behalf of the sole respondent.
Some time to file Bakalat Nama.
Full stop. He has instruction to appear on behalf of the sole respondent and seeks some time to file wakalatnama. Prior sense allowed. Please this matter after
2 weeks. My Lordship, appropriate date may be given.
Give a date.
22 November.
22
November.
22nd of November 2022.
Yes, my Lordship. Is interim order is.
Interim order pass shall continue till the next date of listing.
Oblige.
Yes.
Oblige.
Heard Mr. Learned counsel for the petitioner. This is an application under section 5 of the Limitation Act 1963 for condoning a delay of 329 days, referring the connected appeal against judgment and order dated 30/9/2023 by the special court within bracket POCSO in PSG space SC within bracket POXO case number 20/2022. Issue notice returnable after 4 weeks. MS Swenso, Learned Counsel accepts notice on behalf of the state. Petitioner to take steps for issuance of notice upon respondent number 2 in terms of notification number Swenso, dated Swenso. List. Recorded. Yes, what is this?
My lord, this IA for stay of further operation of the.
What is the decree?
Decree is, my lord, that's a money appeal. This is money appeal. So
What is the amount?
amount is 20 lakhs.
Admitted, appeal is admitted already?
Yes.
The present application is filed. Present application is filed under order 41 rule 5 read with section 151 of the Code of Civil Procedure for staying the judgment and order dated judgment and decree dated 16/5/2023 passed by the Learned Civil Judge Senior Division, Capital Complex, UPIA, Papumpare District in title suit number. What title suit? Title or money suit?
It was title suit, your lordship.
Then
Actually, this suit was filed by the appellant, your lordship. Appellant had taken a loan from the
so you
respondent.
have had counterclaim.
Yes. No, not counterclaim.
His suit was dismissed or decreed.
So
Decree.
Decreed, then why appeal?
Appeal, lordship here, we had filed the case under usurious loan for.
No, please
reduction
tell
of-
us. Please tell us who was the plaintiff. You are the plaintiff.
yes,
Your
appellant
suit
was
is
the plaintiff.
decreed or dismissed.
It's decreed, Your Honor, but there's a conflict with regard to the rate of interest. That's the challenge in our appeal.
So there was a decree.
Yes.
What was the amount of decree?
Decree amount was 20 lakhs,
So
40,000.
according to the suit, you need to pay 20 lakhs.
No,
My
no.
lord, I need to pay.
The
You are
appellant
the
was,
plaintiff.
appellant was need to pay.
Who filed the suit?
My lord, I.
Suit was
an
filed by
suit
the appellant, your lordship.
Under the
You,
usurious loan act.
you file a suit.
Yes.
What was your claim?
Under the usurious loan act for reduction of interest.
For deduction of interest.
Rate.
Now that has been
Decreed.
in your favor by deducting the interest.
Yes, ma'am.
Yes, it was completely
Lordship,
on his favor.
Hmm.
But
Lordship,
now
we are
again,
challenging the calculation arrived by the learned CGM.
Hmm.
Here in this case, Lordship, I have taken a loan of 15 lakhs
From?
the
Respondent,
party
yeah.
respondent.
Okay.
And within 7 months, I have repaid 10 lakhs.
Hmm.
And the learned trial judge had passed an order whereby a 15 lakhs amount has been taken as principal, and on that 15 lakhs, 10% interest I've been made to pay for 10 years.
Hmm.
My contention, my lord, here is since I had paid 10 lakhs out of 15, that should be deducted from the principal amount and remaining amount.
Now, according to you, what is the amount to be paid to him as on date?
that is your lordship, 20 lakh 40,750 rupees. It is a decree amount. You.
I am surprised. Decree is.
So, lordship.
Okay, let us see the decree. You learn every day new things. Yes. Where is the suit? Let us understand.
Suit is your lordship. It is in my paging is not there. After
Okay.
page 11, 12.
The present you have written a constituency.
Your lordship.
The
This,
suit was filed by the present appellant for declaring the petitioner took a loan from the respondent, is that it? Took
Yes.
a loan from the respondent. However, responded. However, the petitioner filed a title suit, being title suit number 36 of 2017, seeking declaration that interest of the loan's interest is excessive, exorbitant, and accordingly paid reduction thereof. The suit was decreed by the learned trial court to the effect that, where is the decree? Judgment, decree. Yes.
Yes, that is in IA, your lordship.
Decrease in IA?
Yes.
Not in the main case?
Not in a main petition.
In the front page.
Front page of what?
Of our appeal.
Or the Dana has fallen in Bhubaneswar. It was decreed, and I think from SC, isn't it? Huh? Huh? For a sound system. Okay. Accordingly, suit was decreed, and accordingly, the plaintiff was directed to repay the loan to the defendant at the interest rate of 10.10 per annum on the principal sum. Accordingly, the plaintiff was directed to pay the defendant total amount of 20,40,750 only, with future interest at the rate of 6% per annum from the date of decree to the date of payment. Kindly see page 10 of the it is contended that the connected appeal
Yes.
Lordship, we are ready to pay as per the current interest rate of the bank. Lordship, we are ready. Lordship, we are ready to pay at the rate of 10% per annum on 5 years.
Yes.
So, my lord, section 10.